Much.
All right.
Good morning, Ms. Baker. Before we get started here, I just want to make sure your audio is coming through clearly.
It is. Thank you very much.
Awesome. Sounds great. And will you be sharing anything today for a share screen?
I will not be.
Okay, thank you so much. And also, Chair Surratt, you're starting right at 9 o'clock? We are waiting for a few more people. Just want to make sure.
Sorry, I had another screen up. We'll give it a minute and make sure we get everybody on here.
Okay, and we'll still be keeping track of the list, so we'll go ahead and let people in as we along the way and everything.
Okay, great. I appreciate that. We haven't successfully gotten Miss Green on here, correct?
I do see Miss Green in the participant list. Miss Green, are you able to hear us? It looks like her mic is not working. Miss Green, would you like to call into the meeting? You could do it via phone. So I could go ahead and guide you through that. So on the mic button, on the right-hand side, you're going to see arrow pointing up. Go ahead and click that for me, and then you're going to see the option switch to phone audio. And then go ahead and click switch to phone audio. And then go ahead and dial that number in and the meeting ID as well. And let's see if that works.
And don't worry, Miss Green, we'll wait to make sure we get you on here.
Miss Green, if you need more assistance to communicate with me, you could go ahead and use the chat button at the bottom of the Zoom screen call. I'll go ahead and start a chat with you, and if you need any help, just let me know.
For the members of the public that are listening right now, we're just trying to work out our technical details. We'll start the meeting here soon.
Sorry about that, everybody. It's April Green. Can you hear me?
Yes, we can. Perfect.
I was on my foolishly on my work computer.
Well, we can see you and we can hear you now, so we're in good shape.
Great.
All right. I will go ahead and start this meeting. I believe the recording is going. To confirm, yes. Okay. All right. I am going to go ahead and call this meeting. This is the notice of public meeting for the Child Support Guidelines Committee. This is September 30th, 2022 at 9 a.m. We will move on to roll call at this time. And do we have Kathleen Baker?
Present.
And I've got a little bit updated. I need to update my list a little bit. Kathy, we don't have Margaret anymore, correct?
That's correct. Lisa is her replacement
Okay, so Kathy Kaplan
here.
and Karen Cliff,
Present.
Assemblywoman Cohen.
Here.
Ellen Crecilius.
Here.
And then we have Jack Fleeman has been replaced for the Family Law Executive Council with April Green. And April Green, you're present.
Yes.
Assemblywoman Hardy. Senator Harris. Judge Hoskin.
I'm here.
Senator Pickard.
I am here.
Judge Robb. Let me know that she would not be here today. Joseph Sanford. Judge Shirley. Justice Stiglitz. Lisa Swearingen. Say your last name. I'm sorry, I just butchered that.
That's okay. Actually, it didn't do too bad. It's Swearingen and I'm here.
Oh, all right, I like it. And myself. All right, we require 8 for a quorum. We have reached our number, which is a miracle because all summer long, I couldn't get a meeting set that would have a quorum whatsoever. So I'm thrilled right now. All right, we will move on to public comment. Those that are here with the public, you have the opportunity to give public comment at this time. We do time you, and do we have anyone that is available or wants to give public comment at this time?
If you would like to give public comment at this time, please press *9 on your phone or raise hand in your Zoom window. Once again, if you wish to take part in public comment, please press *9 on your phone or press raise hand in your Zoom window in order to give public comment. Chair, at this time, your public line is open and working. However, there are no callers wishing to give public comment at this time.
Okay, thank you. I appreciate that. We'll move on to agenda item number 3, which is approval of the meeting minutes. Let's start with the March 25th, 2022 meeting minutes. Anybody want to
Move
make
to
a
approve.
motion? Okay. Is that Judge Hoskin?
Yes.
All right. Do I have a second?
Second. Kathleen
Second by
Baker.
Kathleen Baker. Any discussion? All right, hearing none. All in favor, state aye.
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 Anyone opposed? Anyone abstaining? All right, thank you. Motion passes. Let's move on to approval of the meeting minutes from May 20th, 2022.
Move to approve.
Motion by Judge Hoskin. Do I have a
Kathleen
second?
Baker, second.
Kathleen Baker, second. Any further discussion? All in favor, state aye.
Aye.
Opposed, nay. Abstentions. All right, motion passes. All right. Let's move on to discussion on the master document. Agenda item number 4, which is exhibit 1. We haven't had any changes unless anybody has noticed that I have made mistakes from any of our votes, but nothing has changed since the last time we reviewed that document. Any further discussion on that document right now? I will tell you for this master document, my goal is for us to get our butts moving on the agenda items that we have. And if we can't, and it's going to take extensive meetings, that perhaps we get some of these initial edits that we have motioned on, approved, moving forward through the process so we can get them onto the NACs. Just part of the game plan here so everybody knows where we're going. And for April Green, I did give her these documents. I did try to get her caught up and up to date where the committee is right now. So she's going to be playing a little bit of catch up, but I know all these committee members are happy to give you any information or assistance that you need, April. All right, we will move on to agenda item number 5. And we don't have Joseph Sanford with us, do we? And make sure he hasn't joined us since we started.
I spoke to him a couple days ago and he did intend to be here. So my guess is he's run into something that's just kept him from joining us.
Okay, then I, as committee chair, will take this agenda item out of order for right now with the hope that we have Joseph join us because he's the one that worked on that language the most and will be able to give us any updates. So let's move on to agenda item number 6, discussion and recommendations on formulas to address new possible administrative codes to calculate child support for parents with more than one child support. We have exhibit 3 and we have committee members Pickard, Cliff, and Sanford that were working on that. Do we have any updates from any of you on that?
Madam Chair, just we've gone through the various iterations and the options. I think the consensus was hard won, but I think it's unanimous, at least at the subcommittee level, that this is just more than we can really try to bite off. There were too many exceptions that were likely to come up. And no other state, well, that's not true. A couple of other states under the Wisconsin model have attempted something like this, but we just couldn't come to any kind of consensus as to what language would actually work in most instances. And then we were, I don't want to say informed, we knew it was coming, but the DWSS system, the child support system has just pretty much been completed, and it doesn't include this in their programming. And so it would probably end up with a significant fiscal note. So I think, and the other subcommittee members are certainly welcome to chime in, but I think our recommendation is to table this until the next go around and see if maybe we can do a little more investigation, a little more work with DWSS IT systems, and let's see if we can approach this in a logical way that wouldn't create problems for DWSS or for the litigants, given the disparity of the, and basically we were looking at the out-of-state impacts, right? If somebody comes to Nevada, but they've got 2 kids in California or New York or something, how do we align them all? There is a system whereby the various states can talk, but there's nothing mandatory. They don't have to make adjustments just because we want to make adjustments. And so it could create some really disparate awards. So we just thought it's probably best to table this for the next go around.
All right, Ms. Cliff. Sorry, if you want to comment.
Oh, I think Senator Pickard summed it up. I do want to add that Judge Hoskin was part of those conversations. So it was nice to get some input from the bench in terms of what this would do for the court and the impact. And so we're just trying to balance the needs of the parties, setting a right-sized order, but also not entirely removing the discretion from the bench. But at this point, I agree with Senator Pickard. We just need some more time to discuss it. So.
Okay, is the desire to table it, or would you like me to remove it from the agenda and put it back on when you're ready?
Yeah, let's remove it from the agenda. And then when we reconvene after this next session, we'll review it then. And I almost forgot, I promised Judge Hoskin to throw him under the bus and blame him for torpedoing this thing. So I'll do that. No, I'm kidding. It really was a consensus. Joe and I were probably the most personally interested in this. And even we agreed that just the way we were approaching it wasn't really going to work very well. There were going to be more exceptions than the rule. So it just, I think we need to pull this and then we'll do it next go around.
Okay, well, as a comment from the chair, I would say, I think we set you guys out to do something we knew was impossible, but we wanted to at least take a stab at it. And we know it's an issue, and maybe it's an issue that I don't know that this committee has a way to tell the feds, hey, this is probably a nationwide issue where there needs to be a system put in place for all the states, right, on how to approach these. But I appreciate it. Does anybody else on the committee have any comments to add to this? Okay, hearing none, I am making a note for myself. Remove it from the agenda. I apologize now, but I'm trying to do a better job during the meeting of editing for the next agenda so that it's current in my head and we know exactly what the agenda is going to be. All right. Hearing no further comment, we'll move on to agenda item number 7, which is discussion and recommendations on the proposed language for NAC 425.115 subsection 3 for joint physical custody to change the language to 1/2 of the difference versus the full difference in child support values. This is an item that has been held over a couple of times because we didn't have the proper individuals on the call from DWSS to comment on this. We were waiting for their input. Is anybody prepared to do that today?
Madam Chair, this started out as my suggestion, and I think where we are, although we still need Judge Hoskin to explain what the household makeup means, because we do need to kind of flesh that out. But at the end of the day, you know, we reviewed the DWSS concerns. I personally don't buy into this thought that it's going to cause mass migration to public assistance, given we're talking about the difference. You know, those views, although I certainly respect them and agree with them to the extent that they deal with the impacts on one side of the equation, they are devoid of any discussion about the other side of the equation, which is the obligor, who is ultimately held responsible for more than his proportionate share of the child support. What's that?
His or her.
Yeah, his or her. Yeah, sorry. I'm tired. Anyway, and so this was a question of fundamental fairness to both sides. And, you know, if we were to argue that, well, you have to do the whole difference to the other, otherwise, you know, it's unfair to the person making less money, then the 30-30 rule that we use down here, where we equally divide medical costs, you know, out-of-pocket costs and education costs and extracurriculars, that would similarly be unfair to the recipient spouse, because that is an equal division, just like we're proposing. So this would bring the child support division in line with what we do with everything else. It's a matter of fundamental fairness, and so that's why we think this is an appropriate approach. That said, basically, it's really just the only adjustment is making it so that half, instead of the entire difference paid to the recipient spouse, it's half the difference, so that they meet their equivalent duty under NRS 125C001.
Okay. Do we have anybody from DWSS that wants to comment? Because we received the written comments, but we held this over on the agenda for oral arguments, the wrong word, but for testimony, there we go, from DWSS specifically on this issue. Is there anybody that's going to do that, or are we moving on with actually looking at the possibility of a motion on this?
So this is Kathy. There's no additional information. It was my recollection that the committee wanted to do their own research. I gave them the links to the North Dakota comment about their guideline committee and how they approached it as well. But there's nothing additional to add other than the written response that we provided. And so I don't have anything additional at this point in time.
Okay, thank you, Kathy. I just wanted to make sure I wasn't missing an element there. Any other committee members want to make a comment on this at this time?
Kathleen Baker for the record. I just wanted to check on this particular provision. Would it only apply if the parties shared joint physical custody of all their children? Because if we had a situation where I had primary of 2 and shared joint physical with the other parent, it would be very difficult to figure out any kind of calculation because you wouldn't want to take the difference and then cut that in half if I've got 2 of the kids. So would we be limiting this provision only to those cases where all of the parties' children are in a joint physical custody arrangement?
Madam Chair, if I may.
Yes, go ahead.
I would think the answer is no, only not because we wouldn't want to make it clear, but because we've already built in discretion for the court to address the split or the different custody arrangements. So that would be a discretionary question for the court to right size the award. So I wouldn't want to limit this only to those because that would limit the court's discretion in those split custody situations. I would imagine that the courts would, and I'll let Judge Hoskin chime in on this, obviously, but I would imagine they're going to look at the totality and try to right size it after the fact through the adjustment factors, which would obviously play into how this would work. But anyway, Judge Hoskin, you undoubtedly have an opinion on this.
He threw you under the bus. You don't have to comment unless you'd like to, Judge.
Well, no, and I've expressed my concern with this approach several times. It's just, I have a hard time understanding, and I appear to be one of the few, how this is a better approach than what we've been doing to this point in time. But to get to Senator Pickett's question, the reason I really love these new guidelines is because I have the ability to right size it. And I think that unless we do something that hamstrings me in that approach, I think I still have that ability. So I think the answer to the question is yes.
This is April Green. I have
Yeah.
a comment.
Yes.
You know, working at Legal Aid and being very familiar with the needs of Nevada children and the number of children, the great number of children living in poverty, whether they're documented or undocumented, just looking at the abuse and neglect system and the things that children are going through, I really don't think equalization of income and fairness issues are the point when we're talking about child support. Child support is for the support, the basic, meeting the basic needs of Nevada's children, and to just make a blanket cut in half without any particulars regarding a family's situation, I think the impact is going to fall on our children. And we need to look at that. I don't see how, and this is my first meeting. I don't know if research was done on poverty numbers and impact for something like this, but I think that's what, we should be looking at before even thinking about, making a motion and making a recommendation on something like this. I'm always personally thinking about the impact of children's needs not being met and how they just grow and blossom into crime, and it's just bringing society down. We got to think about meeting these children's needs. So if one parent is making more and they're, supplementing in a sense the income of the other parent so that rent can be paid and food can be put on the table and clothes for school and so forth can be purchased, then that's a good thing, and to me, it's sad that the parent wouldn't want to do that. I know the other parent has their needs, but it's about children. To me, it's not about making it fair for each parent. It's about making sure in both households, when they're at both households, that their basic needs can be met. And I think until we start looking at some of those numbers, how could we ever make these kind of changes, just blanket changes? I don't see how it's fair to our children. That's my comment.
All right, I'm going to give my comment, which is this entire committee has been based on all of our calculations, looking at poverty levels and the calculations. So the calculation that started with did look at those conditions. In an abuse and neglect scenario where one parent is the abuser, this doesn't apply. This is joint physical custody. So what we're saying is that when the child is in the other home, the payor's home, 50% of the time, that payor deserves to have less money for that child than the recipient. The recipient gets more. So the way we do the math, when we do this calculation, we create a pot. This is the child support pot based on my income, based on your income. This is the pot of child support. And then what we're saying is you get to have more of that pot and I get to have less of that pot. And I get to dip into my income even more. So the complaints and the public comment that we receive is always from the payor who's going, I'm paying so much that the recipient is living well and doing great things with the kid, with the child support, but my payment is so high, I can't do it. And so that's the right sizing, and that's based on ability to pay. And there are a lot of other factors there. But why would we start with saying the pot is unequally divided? When we said, this is how much you can pay, and this is how much you can pay or should pay under the child support calculations, put it in a pot. And then we say, nope, it's desperate. We're not going to do an equal division because just because you're the higher earner, you get less of that pot. You already paid more into the pot. It's just where do we put, how do we do the pot? So when we say the child is automatically in a joint physical custody scenario, going to the other home and having great needs that were beyond, their ability to pay, that's not necessarily the case. And so it's a lot of times the payor is the one that's barely eating, barely able to care for the children. And when we say more, it's not often tons more. Often it's just barely more, but it's enough to impact that home. Child support can put people in a situation where they barely meet their own needs. And there's a massive ignoring of the payor's needs. And I'm not talking about their needs. I'm talking about when the children are in their home and their ability also to pay for the children and do things for the children. When we do everything else in divorce, when we do our balance sheet in a divorce scenario, we balance it. We don't say they pay the difference because that's not fair. We're looking for fairness. And so it's half of the difference and we balance it. It's not pay the difference because that's not fair. And so when I take all that we received in public comment, I don't agree that we're not looking at poverty levels, that we're not looking at the needs of children. Now, what I'll tell you is that when we did, and when we came up with these math calculations and we came up with these percentages, the reality is no child support calculation can we do that really meets the needs of the child. Children are more expensive than what child support provides. And when the payor is taking care of their children 50% of the time, that needs to be part of the consideration. And all we ever say is that, oh, well, they make more, even though they've got their children 50% of the time, with no consideration to that. Other committee comments?
Madam Chair, I'll jump in since nobody else is. I really struggle with the idea that fairness to the parents should not be considered. I understand the impulse to support kids. In fact, I just went through 3 days of trial trying to get an obligor to meet his burden that he agreed to in 2016. And he's got child support and alimony arrears totaling $85,000, and we can't get anybody to hold him accountable. And we're talking about a mom who makes all of $3,600 a month, and dad makes $10,000 a month and wouldn't pay what he agreed to. I certainly feel for that low income, and 3,600 isn't on the low income table, obviously, but she can barely make it. In fact, her expectation was that she was supposed to be getting almost almost as much as she was earning from dad in total support in order just to remain here in Nevada. And then when he cut her off at the knees, she ultimately had to move because she was being evicted, and while dad was moving into nicer residences. So I certainly understand the impulse to try to get as much as we can for the kids in that lower income home. But at the end of the day, our whole system, our whole child support system, as you said, is based on fairness. And it's fairness to the people that are providing the income. And in 2015, when we pushed AB 263 through that established NRS 125C001's requirement that each parent has an equivalent duty, not a numerical equal duty, but an equivalent duty to support their kids. That was in direct response to this issue. And the legislature passed that bill. And it wasn't a very close call. I mean, it got through, it had a little more struggle through the assembly, which is no surprise, they typically do, but it got unanimous support in the Senate. And so I struggle with this notion that we should jettison fairness just to provide kids in low income households additional funds. But I struggle with that. But at the end of the day, I think, unless somebody else wants to chime in, I'm ready to make the motion to approve this.
Kathy Baker for the record. I've been sitting here and I've been trying since I looked at this idea, if I have primary of 2 children and we share joint physical custody, how that calculation is going to work. If I were to take, and I just was running some sort of vague numbers. So if I have one parent with the primary that's earning $2,600 and she's got primary of 2 and they share joint physical custody and the other parent earns $4,200. Under our current situation, we would take 26% of the $4,200 and we would subtract 16% of the $2,600 for the difference. That would be $676. That's basically, I have primary, I'm getting $676. If you cut that in half, I'm now getting $338. And I have primary custody of 2 children. I think that Judge Hoskins has.
No, it's joint physical only. This scenario does not apply to primary.
That was my question to begin with.
No, it's just joint.
But if I have joint physical of 1 child and primary of the other 2, how are those calculations going to work? Right now, we offset it. How do we adjust for the fact that I've got primary of 2 and joint physical of 1?
In my experience, there are very few of those cases. I mean, I really never see them myself. I know they exist. I know there's some, but they're usually teenagers when you start having those scenarios where they, start forcing their way to and expressing their desires to live with 1 parent. That is not a major number of my cases or cases I see out there. So those are discretion of the court. I mean, we're talking about vast, large numbers of joint physical custody cases. And I get that on the DWSS side of it, the DA side of it, you guys aren't seeing as many joint physical as we see in the private world. Because usually they're contested cases and you're dealing with, another end of things. But I see a dramatic number of joint physical custody cases where it makes no sense that the check's being cut the way it's being cut. And we have the discretion of the court to still fix on ability to pay and still fix on those cases where you've got those circumstances. We have a whole nother statute that may need some adjusting with this. That deals with you brought it up for the agenda when there's 2 and 1 and the different combinations. But in a straight up joint physical custody of all kids.
And as I started out, if we're talking about, I think they're apples and oranges. I think when you have joint physical custody situation with all children, that's one thing that you're talking about. But right now, our scheme does not account for the separateness of those two things. Because I don't know about Ms. Cliff, but we see quite a few cases where we have a split situation in terms of primary and joint. And that's a calculation that needs to be addressed if this committee is going to look at cutting the amount for joint physical custody in half. And I don't think we can just ignore it, because we're going to go into court. It's like, okay, well, how do we do this? If this is what the calculation says, and this applies across the board, it's not going to meet the needs of the children in that type of scenario.
Okay, additional committee comments?
Madam Chair, if I can ask a question and perhaps I'm just missing it. Is there proposed language for this change that was provided for this meeting, or is it something from a few meetings back?
It's from a lot of meetings back. Yes, there was proposed language at one point. It was right when we restarted back up. I will have to dig through the files because it's just been carried over on the agenda.
Yeah, I just know that Senator Pickard said he was ready to make a motion, and I'd prefer not to vote on something I don't have the language in front of me for.
Well, and I think
I
that's
thought we
probably-
had it.
I don't know. What we had originally was your bill from the last session. And that's probably a fair statement that we need to get language in front of the committee. We have been hashing it out versus getting to that point.
Yeah, and I thought I saw it in the enclosed documents, but
No, I know that it's not in those ones.
yeah, I'm a little concerned about the timing, if only because we're getting to the end of the point where DWSS can put these things together in time for LegCom to pass on them.
Well, I would agree with that. But I am, because of several things we've got on this agenda, going to try to, and now that we're out of summer break, my hope is we can have an efficient next meeting. I really believe we can do that. Summer break, I think, caused us all the problems. And too many vacations. So as long as I can get a quorum for another meeting, on the rest of the things that we're talking about today, I'd like to be able to wrap that up and get this off to DWSS. So if we can bring that language in the next meeting.
Sure.
Okay. All right. Let's move on to agenda number 8. Judge Rob is not here. And this one has only agenda item number 8, discussion and recommendations, clarification of NAC 425.025 1M, and then subsection 2. This only got carried over because we all wanted to continue to wrap our heads around it and think about it in the last meeting, and see if there was anything else we could do with it. We don't have Judge Rob today, so I'm going to move on to the next agenda item unless anybody has some deep, great desires to talk about that agenda item. Okay. Agenda item number 9, discussion and recommendations on NAC. Sorry, I'm going to keep a note. Agenda item number 9, recommendations on NAC 425.110 subsection 1D to account for the possibility that TANF could have a name change in the future and the successor program names should be included. My recollection from the last meeting was just that we were just holding with our language change to make sure that DWSS didn't want to make any additional tweaks to that or come up with any other issues on that language change.
So Kim, this is Lisa. We do not anticipate a change to the TANF program, the naming of that convention.
The
at all.
naming. Yeah. I know you don't anticipate it, but the reason this is on the agenda is just only because it came up, randomly. But this committee's job is to try to help keep things running smooth without having to go through this whole process to make little changes if it does happen to change and make things go a little smoother so that we're not having to, you guys are suddenly in a bind at the end of the day just because of that. A suggestion had been made to say TANF or any, oh, hold on, let me look at the language. I was about to speak out of turn. Let me look. Let me get there. Oh, no, we didn't put it in there. Anyways, the discussion was just TANF or any, what was it, Senator Pickard? What was the language request? I think if
I was just looking for it and I
Yeah.
can't find it in my notes.
if DWSS is good with it just saying TANF and has good confidence that this isn't, if the state of Nevada suddenly changes the name or something cause you problems, then I don't foresee us needing to do anything else unless
My recollection was that
I need to.
suggested language, adding language that said TANF or a subsequent replacement program or something to that effect. I don't remember the exact language, and that's what I was just looking for. We talked about inserting something that says it's replacement program.
So as the former chief over the TANF program for the state, I would say that we do not anticipate that changing anywhere in the near future. It was ADC and ADFC for years, and that's been the TANF. I think it's been TANF since, I want to say probably close to 2000. I don't see that they're planning on changing that anytime soon. So I would be comfortable with keeping it as TANF.
Okay. Our child support statutes hadn't changed since the 80s either before we started doing stuff. So we're just making sure we're covering our grounds and not causing you more problems.
I think you're
have
fine.
any additional comments or want to make a motion on any of that?
If I may, Senator Pickard's right. It was or subsequent whatever, and it was just whatever language that LCB always uses to say or subsequent whatever. But
Do we feel like we need it?
I don't think it hurts to ever have that language because, as you said, we had the same thing for a long time until we didn't. So I think it just covered bases. But since we don't remember what it is right now, I don't know that we could make a motion on that language that we know that there's language, but we just don't remember exactly what it is. So
we could make a motion for LCB to appropriately list that.
Oh, that's true. I would be okay with that because I just think it's always good to cover those bases, but it's not a hill to die for me.
I agree with Senator Cohen completely. But I actually am not concerned about this, given we have the standing committee. And if Congress were actually able to do something and to make that change, then we could respond to it quickly.
Okay. So do we have a motion or are we moving on? Okay. Hearing none, I am permanently removing it from the agenda. Okay, item number 10. Actually, I want to make sure I get to item 11, although we're doing good on time, aren't we? But let's do agenda item number 11, just so that I make sure we cover it. Discussion and recommendations on conflicting language between NAC 425.160 subsection 1 and subsection 2. The obligation termination conflicts between the two paragraphs. Ms. Kaplan, you brought this agenda item forward. Do you want to address it or have somebody else?
I can address it. Thank you.
Okay.
So in paragraph number 1, the obligation ends when the child turns 18. And that could be prorated if they turn 18 at the beginning of the month or whatever. But if you flip down to paragraph number 2, the obligation for that child emancipating doesn't end until the beginning of the following month. So in our new system, we have the ability to prorate. And so in paragraph 1, where there's only one child in the order, the obligation could end at the first of the month because that child turns 18 and emancipates at the first of the month. So the NCP wouldn't be obligated to pay the entire monthly obligation. But in the second one, where there's duplicate children, they have to pay for that emancipated child for the entire month. Does that make sense?
Yeah. Do you have a proposal on which way you prefer it to be?
I do not. I'm leaving that up to the committee. I just, as we were working through issues with the new system, it was brought to our attention. They're like, well, what do we do and where do we set that emancipation date? Because it's not consistent between the two paragraphs.
Okay, so there's not one that would work better with your system right now versus the other.
Correct. We're going to leave it to the committee to make that determination. We're just bringing it forward that there is a conflict.
Okay. Any committee comments?
I have a question on that. This came up actually in this trial that I'm in the middle of. Peter James is on the other side, and he likes to make constitutional arguments. He actually argued that the way the entire section is written is unconstitutional because it treats children differently, even though it's my understanding that we have only one. And in fact, he suggested Judge Hoskin agreed with him at a CL or at the family law conference. But the thing that I don't understand is how would we do this within the child support system if we didn't, number one. Now, I agree with aligning the effective dates. That makes sense. That's a conflict that can and should be resolved. But it's what happens when we do have a child age out. We require that a motion be filed. And his argument was, I thought it was interesting, in that he's saying it's unconstitutional not to make it automatic, and that we somehow automatically adjust the child support immediately. Is that even possible within the system?
Well, we also, during our committee meetings, when we were discussing this, went through what we could constitutionally do or not do.
Right.
And due process is the part of the constitutional argument that he's not making there, or
Right.
isn't being made in that argument.
I made it. But
children being treated different versus the due process issue.
Right.
Because with the multiple children being heard on what your income is at that time, having the right to be heard on that was part of the issue for to have a recent current calculation done and all the evidence considered at that point.
Right. Absolutely. And that was my response. But my question is for DWSS. And so, Kathy, maybe this is a question for you since you are handling the new system. Is there even a mechanism that could happen in Nevada?
That what could happen, Keith?
Right. I'm missing the what.
Senator, I'm sorry.
I'm sorry, the automatic, that as soon as a child emancipates, that the child support is automatically adjusted.
Yes. So we do have it in the system. If we set emancipation for, say, the second of the month, it would prorate that monthly amount to only include 2 days, and then the current support is not due.
All right, how would we then put that in the order? What would the order look like for us to, because we don't do child-specific orders the way we've done it, because we've got the calculation based on the number of kids and we don't break those up. So it's not like if you have 2 kids and it's 22%, it's 11% per child. We don't do that. So how do we put that in the orders?
I honestly do not feel like I can make that comment. I
Well,
don't
and I
know.
will say that that's not on the agenda item. That was discussed
Oh.
and determined by
Good
this
point.
committee, and it's not part of the agenda. What's part of the agenda is aligning whether there's a prorated amount for the month, or
Right.
does it go to the first of the month following the date that the child emancipates?
Right, and that's.
That's what's on the agenda.
No, I get that. And that was, part and parcel, the argument that was being made. And I thought, well, this is perfect because we're going to be talking about this today. So I probably shouldn't have mentioned the equal protection argument, but I thought it was interesting because it's exactly what we're talking about today, aligning these. But it sounds like it is possible and it can be done.
Kathleen Baker for the record. Senator Pickard, it's my understanding that the only time that the system automatically handles the emancipation is if there's only one child. There
Oh.
is no way for it to automatically recalculate when there is more than one child, which is why we used to have those per child orders. So it seems to me that if that's the case, if that's one of the factors that we're looking at, and if we cannot automatically adjust at the emancipation date when there's more than one child, that the consistent approach would be that we have both of them where it's, after the child turns, a month after perhaps.
Okay, that would make sense to me.
And you are correct, Kathleen Baker.
Ms. Cliff, do you have?
I'm just.
I heard rustling.
This is Karen. I was getting nervous when we talked about prorating child support. That's a scary direction to go. Just because expenses, in my mind, in this world, it's due on the 1st, it's late after the 30th or the 31st. Those expenses sometimes are they're incurred by the parent. It could be on the 1st. So I think it's just sort of a detrimental reliance on the custodial parent to suddenly prorate child support. I think it's just really going to be difficult, not just for the individual counties, but just to enforce something like that. So I would go with the month after, which is what we've been doing in Clark. So that's my
And
vote.
in Washoe.
Yeah, and if I can weigh in, Madam Chair.
Yes, sir.
I think from the private standpoint as well, what I don't want is litigation before me because one parent calculated it on 30 days and the other parent calculated on 31 days. And now they've got a motion in front of me to make that determination. I think if we're going to go any direction, let's take it through the end of the month of the child's birthday and it'll terminate at the end of that month.
I agree. I think proration would be a nightmare. I think attorneys can't do math, right? We're really bad at math, and pro per litigants certainly would have trouble with it. And I think Ms. Cliff makes a really good point. Rent is due on the 1st. And yeah, that kind of solidified it for me when she said that, because even though I was originally thinking proration would be a nightmare. But yeah, certainly you're making a lot of expenses are due at the 1st. And yeah, I would just say leave it alone and it's the beginning of the next month and leave it at that.
Okay, so for clarification, both section 1 and 2 would need to be modified so that it's not just reaching the age of 19, but it's the 1st of the month following reaching 19. And 1 needs to add that it's also the 1st of the month following graduation. We need to make both of those have both of those, right? It's okay.
Well, sort of, except that it could be 18. There's an or in there. It's
Or.
not just on 19. So the language has to be after whichever first occurs and then go into the following month.
Okay, yeah. So whether it's 18 or 19 or it's graduation, we want all 3 of those scenarios to be the 1st of the month after that date hits.
After the event.
Yes. And would it make sense to just say that the obligation terminates at the 1st of the month following when the child reaches?
Obligation terminates and then go into the 18, 19 and graduation.
Yeah,
Well,
all we
yeah,
would have
that's
to
how it
do-
is in 2.
Yeah,
Yeah, just move that language to 1.
right.
Yeah, okay. Then let's do this for the next meeting, so we get the actual language in front of the committee for an edit. Ms. Kaplan, do you mind creating that language for the committee to consider based on the input you just received?
Sure,
Okay.
I can attempt. I am not an attorney. And
Well,
so
would you rather another committee member volunteer and we can get somebody else assigned?
and that might be better. Like, you guys will probably pick it apart if I put it together. So
I appreciate that sentiment.
my feelings might get hurt. So yes, if somebody else wants to take that on, I would be very grateful.
Not
I don't
a-
mind.
It'll take me
Ms.
about
Cliff?
Or-
All
2
right.
minutes.
Okay, this is Karen. I don't mind making the change, and then I can just, work with Kathy and make sure that that looks good, and we'll present
Okay.
it next day.
Okay, beautiful. So let me make a note for myself. Okay. Now let's go back to agenda item number 10, discussion and recommendations on the means for division of medical costs, including whether the term equitable should be utilized for division. We had this has been a carryover for a while because at times during our meetings, we didn't have the right people or the right input or people considering things. Does anybody have any updates on or input on this agenda item? Are we moving anywhere with it? All right, hearing none. I don't know that there's any edits in front of us, additional edits. I think it was just everybody wanted to sit on it and really make sure we were in the right place with it. So for now, I will remove it from the agenda. And if at some time in the future, there's a need for it, or we need to adjust it again, of course, everything with this committee is back on the table, so. Okay, this is an efficient meeting today, everybody. We've got our next agenda item number is 12, discuss and approve ideas for future agenda items and the next meeting date and time. We only have a few items left from our carryover topics. Probably the biggest one will be from Joseph Sanford, which is just the cleanup language that we've seen, but he was still working on, and hopefully we'll get that in front of everybody in plenty of time. For a good solid review, but does anybody have additional items that need to be added and discussed on future agenda items? Keep in mind, I'm kind of looking at what we need right now to get this next version out to DWSS versus, a restart of this committee again right after session when we start bigger, newer issues that are big ones for us to keep tackling. God, that was very inarticulate, but hopefully everybody understood what I was saying just now.
You're starting to sound like me.
Oh, I can't ramble that much, Senator. Any agenda
Okay.
items anybody wants to add? Okay. We reset this meeting so many times because of our quorum issue. My hope is that we have a meeting towards the end of October. I am going to hold off on setting that date till I talk to Joseph Sanford, because his is that big piece element that we need in our next meeting to go over and make sure that everybody gets it in time to look at. I know Mr. Sanford is extremely efficient and does a very good job, so I don't think it'll be problematic for me to set that, but we will. The best approach we've got right now is set a date, send it out, and then Joy can, DWSS can collect the approvals of the meeting or not, if you accept it or decline it, and that's how we know if we have a quorum and whether we're resetting it again. I know it's not exactly the best system, but it's hard to coordinate this many people on this many calendars. All right.
This
With
is
that,
Karen. I
yes,
just want to add, I know typically we meet at the last Friday of the month. In October, that's Nevada Day. That doesn't preclude us from
Yeah.
meeting, of course, but just when Joy's picking a date.
I will avoid Nevada Day, I promise. We typically pick Fridays mainly because it's easier on our judges to attend. So that's the main reason for that. And so Ms. Green, so you know, we always start at 9. I don't let us go past noon. Thank goodness we're kind of narrowed down on this committee, so we're not dedicating that many hours today. But do we have
Kathleen,
other
may I-
agenda items to
I
add?
actually have a request. I was trying to look for I got the agenda with all of the exhibits, so I was scrambling to try and find all the exhibits because they were not sent earlier. And I couldn't find them all. If it's possible, when we have the agenda sent out, if we could also have copies of the exhibits that we're going to be talking about, I think that would be very helpful for those of us who can't always find them.
Yeah, part of that is committee members getting them turned in so we can get them out to everybody.
But we
Timely.
referenced exhibits that had been filed before and we didn't.
Oh, yes.
have. And so those are the exhibits I'm thinking about. If we're going to have old exhibits brought forward, maybe those could be included with our agenda.
We can do that.
Thank you.
Yes. And this might be a good time to ask, just in terms of administrative on the agenda part of it, from DWSS. The last time I looked at the website, it still was a little behind on posting stuff, but do we have an update on posting the old hearings and minutes and everything on there?
I do not have an update on that. I
Okay.
was not aware that it was behind. I will go find out about it.
Okay,
The-
yeah, it's the old stuff, only because when we bring on new committee members, it's helpful for them to be able to see the old. If you recall, Margot commented that the DWSS was going to do that because really it's the only housing we have for those old. And I know on the videos, they had to be brought into compliance on ADA to be able to be put on the website. So that's the reason. It's not a, we know why it's behind, I guess is the comment.
And I was thinking that it was completely caught up,
Oh.
so let me look into it,
Yeah,
but
let me look too, just.
yeah, all of the documents
is
do
now.
have to be ADA compliant, and we are really short of staff to do that, and that could be part of the reason, but I thought we were completely current on it. So if you see
Oh.
something different, please let me
No,
know.
I just went in there. I'm now seeing 2017 recordings, which I hadn't seen before.
Okay.
Okay. You're right. It's looking good.
Okay, and the documents are there as well, correct?
They should be. Let me click through here. Yes. So for the committee, I mean, yes, we'll make sure everything with each agenda is put out, but any of the old materials or exhibits should all be on that website. And it's far more extensive than it has been in the past. So that's the dwss.nv.gov. And under that, you can go to, there's a drop down for child support. And there is a selection for the Child Support Guideline Committee. There's a guidelines link, but there's also a committee link. When you click on that committee link, you get the option of the meeting dates, agendas, materials, and the minutes and the recordings. And there's a whole lot more there than we've had before. So thank you, DWSS. I appreciate that, Kathy. And for the public, that's a good resource. That's what you need to go to know what we've been through and where we're going, maybe. All right. Any additional agenda items to add? I keep asking, but. All right. Hearing none, we'll move on to public comment. Anybody that's listening that would like to give public comment, we'll take your public comment at this time. We will time you. You will have a limited amount of time to give. And if we could do that now, please.
If you wish to join the queue to provide public comment, please press *9 on your phone or raise hand in your Zoom window. Once again, to provide public comment, please press *9 now to take your place in the queue or raise hand in your Zoom window. Chair, your public line is open and working. However, there are no members of the public that wish to make comment at this time.
All right, thank you very much. Then I will adjourn this meeting and I appreciate everybody's time.
Thank you, everyone.
Thank you.